The only reason I wrote that because he told me I wouldn't go to jail if I wrote that. He was right here with me, sitting, saying that.
So
I was trying to save her.
We can't accept any of this because it was all done under duress and under a false pretense. She was coerced, essentially. And that's what I need to get very clear because I'm not going to trample over her civil rights because somebody else did.
My mom died of cancer. My brother died of a heart attack.
On August 16th, 2023, officers in Florida responded to a Dollar General store reporting nearly $14,000 missing after an internal audit. A store manager responsible for cash deposits had allegedly been stealing from the company's safe over several months to cover funeral expenses for her mother and brother. But this was not a straightforward theft case. Upon arrival, officers discovered the suspect had already provided a written confession to her supervisor, who allegedly promised she would not face prosecution if she cooperated. The officers now faced a case complicated by a potentially coerced confession.
Please take me back doors. I'm
sorry.
Please take me out the back door because don't put me in handcuffs. Please. They can walk, I don't care. I've been here 2 years, please, I don't.
And that's what I need to get very clear because I'm not going to trample over her civil rights because somebody else did.
It was my brother, it was all just to pay my my brother's funeral. He just died.
I understand. But
he just told me that if I write it, I wouldn't go to jail.
Understand that regardless of what statements are made, right, that is for you to dispute with a lawyer. As far as we are concerned, you have now committed the act of grand theft. That is a felony. We have no choice. We must make an arrest and we must take you in. They are the entity representing the business and they are requesting that we take law enforcement action against you. That is our position on it, okay? Regardless of whether we think that their investigation went right or wrong. As far as we are concerned, we are going to conduct our investigation in the proper order, okay? What's your Miranda?
Yeah.
Okay.
Wow. The only reason I wrote that because he told me I wouldn't go to jail if I wrote that. He was right here with me, sitting, saying that.
So we're not going to take that or use it.
I know.
So that's just going to be something that they...
That's for my record.
That'll be for their records and has nothing to do with us. As far as we are concerned, we will give you the opportunity if you would like to make a statement and we will document it properly.
Okay.
Just a moment here. I'll be sort things out.
Oh, close the door so
Yeah.
Yeah, just relax for a second. We're not quite there yet.
And are you her supervisor normally? Okay, so she's made the statement to us that she was told that if she provided a statement that you guys would not pursue prosecution as long as you did make that statement to her. Okay. I just need to clarify that.
I'm here because I was trying to save her. You know what I mean?
Yeah, I understand.
But the lady is loss prevention.
Yeah.
So she's going to do her thing.
Yeah.
I was trying to, at least, if she was willing to cooperate.
Yes.
I was assuming that loss prevention was going to take that into consideration and accept, like a deal.
Yeah.
But it looked like she...
Yeah, unfortunately. Okay. Those kind of deals. So, because of that, do you have ID so we can just document that we spoke with you and that statement? She's alleging that statement was made. And, so as far as we are concerned, we can't accept any of this because it was all done under duress and under a false pretense. She was coerced, essentially. You've made false pretenses that she wouldn't go to jail, and we have nothing to do with that. But as far as we just need to document that this is the allegation that she's making, and that we properly read her Miranda, and we let her know that anything that she states to us after this point, can and will be used against her. So I just need your ID, and that was all.
No, I'm not going to provide my ID. I don't have to. I haven't committed any crime.
You're part of the investigation as the authorized representative and as her supervisor who brought her in here. You are now part of the investigation.
You can raise your tone.
I'm not raising my tone at all, sir. I've only spoken with you.
I'm not afraid, but I'm not going to provide my ID because I know the law.
No problem.
I'm happy that this is happening. Because I didn't want that to happen to her.
Okay.
But,
That's all.
is 1054. I am showing a couple of things.
I can give you my name.
It's fine. Yeah.
Miguel
And then
Figueroa.
also
Okay.
he has a protection order issued against him.
Is there a voice in the camera?
Huh?
Is there a voice in the camera?
No.
It was all him when he said to me right under the camera right here. I was in jail.
I'm sure you're telling the truth.
So, like this officer said, regardless
I know,
of
I get
what
it.
took place, the crime
I
took
know,
place.
I get it.
So we can't get around that.
I know.
So, and a lot of times, people can choose not to prosecute at first and then change their mind.
Can you
That's-
tell me if
You know what I mean?
my glasses are not working today? I can't really see them.
Heritage 1, 1411, you're 13.
You need the dates. I put from May, whatever, but I can detail the deposits amount that she admitted to, one by one.
Yeah, if you can do that and just like the time frame, you said April, May.
Yeah, my mom passed in April.
Hmm.
And your brother was
Yeah, my
in
brother-
March, right?
Yeah, my mom. Yeah, my mom died of cancer. My brother died of a heart attack. The 2600 one is on the slip. All of them. It was only the 15, the 22, and the 22.
As of this morning, the 2600 is still not in the bank. And that was from,
Yeah,
the
no,
nine.
that one. Yeah, that one
That
was.
was seven.
The yellow slip should be with the ones that were here yesterday. It's only the last, the 15, the 22, and the 22. So the 26 is the one that I faxed over.
yeah,
Scan and send. The 2646 is the one I scanned and sent. It was in there.
well, this morning.
And the 1700 too. No, they're there. This is the one that you had. That one came
I didn't
back.
include that one on that.
Do you have like a photo ID also?
It's outside
He took
with my
mine.
phone.
Oh.
Okay. So were you gonna email me this or?
Yeah. How do you want me to?
No, you can just email me the whole spreadsheet. I'll just.
Yeah.
You just put on email. I'll put my email address. Once we get you searched, I can allow you to.
Yeah, she can come there.
Yes.
Yeah. Get the. So, Miss Howie,
Yes.
need you a couple of. Need you to initial the statement here. And then on this line, you're going to print your name because you want to prosecute on behalf of the business and then sign. Okay. And this statement basically says that you swear and affirm that your statement is true and correct to the best of your knowledge.
The charge here falls under Florida Statute Section 812-014, which defines theft as knowingly obtaining or using another's property with intent to deprive the owner of that property. Grand theft of the third degree covers property valued between $750 and $20,000, classified as a third-degree felony punishable by up to 5 years imprisonment or probation. The suspect acknowledged taking approximately $5,900 across 3 separate deposits, while Dollar General alleged a total shortfall of nearly $14,000. Regardless of which figure applies, both fall within the same statutory range. The classification remains a third-degree felony either way, though the actual amount affects restitution and may influence sentencing. The critical legal issue in this case is the coerced confession. The suspect's supervisor extracted a written admission by promising she would avoid criminal prosecution. This raises serious concerns under the Fifth Amendment and the Due Process Clause. Under Bram v. United States, decided in 1897, confessions induced by promises of leniency or immunity are considered involuntary and therefore inadmissible. The lead officer handled this masterfully. Upon learning of the supervisor's promise, the officer immediately declared the statement was obtained under duress and under false pretenses, and that it could not be accepted. He then took the correct procedural step, advising the suspect of her Miranda rights and offering her a fresh opportunity to make a voluntary statement under proper legal safeguards. This approach aligns with Oregon versus Elstad, decided in 1985, where the Supreme Court held that a properly Mirandized confession is not automatically suppressed simply because an earlier unwarned admission existed. The key question is whether the subsequent waiver was knowing and voluntary. By creating a clean procedural break, the officer protected both the suspect's rights and the prosecution's case. There is an important nuance here. Under Colorado versus Connolly, decided in 1986, the Supreme Court held that coercive police activity is a necessary predicate for finding a confession involuntary under the Due Process Clause. Since the coercion here came from the employer rather than law enforcement, the constitutional analysis differs. Private party coercion does not automatically trigger Fifth Amendment protections. However, the officers wisely chose to treat the employer-obtained statement as tainted regardless. This decision was both ethically sound and strategically smart. Using a potentially coerced confession, even one obtained by a private party, invites suppression motions and appeals. Building the case on independent evidence, the audit records, deposit slips, and the supervisor's sworn complaint created a far stronger prosecution.
Can I take my debit card out and give it for my daughter? Just give it to the girl that works here and give it to my daughter.
Paper copies, Canada,
Oh, the girl
State,
that-
except Northridge.
Yeah, the black girl.
The girl that's working at the...
Yeah, the black girl. No, the tall one.
Yeah.
Jen. Because I have to get
Yeah,
in case I
take
need her to get
whatever
money
you want to give to her out.
out. This one. My license to stay with her.
Yeah.
It's okay.
Oh,
And then, yeah, 'cause that's for her to give to my daughter.
okay.
Because it's Jen out there.
You want me to call her in here? Or
Jen.
you want me to give it to her?
Yeah, if you can call her in here, I just want her to give them to my daughter in case my daughter has to get money.
Yeah, we can give it to her.
It's for Jen, not Carla.
Jan.
Thank you.
I
I
don't know
only
what the...
acknowledge the 1,500 and the other 22 and 22. That's it. It's not those other ones. It's just the last ones. And the
Yeah.
and the 222s.
So, yeah, well, like this one and the 222s.
Yeah, it's the 22 and the 22.
1, 2, 3.
Yeah. The other ones, I dropped them off at.
Okay. Well, the amounts that the charges go is anything over 5,000, between 5 and 20,000. Like the same charge. So whether it's 6,000 or 10,000,
Right.
it'll be like the same bond.
It's not gonna be how much cash will she need?
Special Calculator 108 Garrison Drive, check moving of Phoenix, Penelope. Reference hasn't heard single 43, I know where they are.
I haven't done a second degree misdemeanor in a while. First one is like 3, say between 5, 6,000. Not 100% sure.
Like $500 cash then?
Yeah, like if you do like 10% bond.
Right. Like, oh my god, please, because nobody knows anything. She's gonna be the one that's getting me out.
Hello?
Hey, Tori. Can you hear me?
Are you okay?
No, what jail? Don't worry and don't tell nobody, but I gave Jen my debit card at work, so you can call her on Facebook.
What?
They're taking me to jail, so if you could bail me out.
Why are they taking you to jail?
Because of deposits. But, I mean, I didn't go yet, so I don't know how long it's gonna be, but what does she have to do? Hey,
What
Kyrie.
deposits? What are you talking about?
At work. I'll tell you later, but what does she have to do? The police officer's right here. You're on speakerphone. Hey, Kyrie.
When they're ready
Sorry,
to,
my grandson.
when they're ready to
Alright, puppy, hold on.
Hey, Kyrie.
bond you out, they will allow you to make a phone call.
Jen at work.
And,
Okay. They said when you come bomb me out later on tonight, I don't know how it's gonna be. I guess you just have to look online.
Are you stealing money, bro? Back 1411. All advised that the homeowner should be the mother's brother.
Oh, my grandson loves me. Sorry. Kyrie, it's okay. I'm right here.
Hi, Grandma.
Hey, Kai.
Okay.
Hey. Hey, so how did she look it up?
No,
So do I have to go to the
you
store
or
and pick up my
someone
car?
will call her when you're ready to go, and
Alright. I'll call you when I'm ready to go. It could be a couple hours. I'll explain to you later. This is embarrassing enough. So, Tori, for my one card that Jen has, the Amscot one, the $900 one, you have to go to Wells Fargo and you can only take out $300 at a time. So you have to do 3 transactions for $300.
Alright.
So,
I don't know if I could take off today. I'm gonna get in trouble with work.
yeah, don't tell nobody else.
I'm not. If you needed help, why didn't
I
you
know.
ask me?
Alright, I have to go.
instead of
Please,
doing
right
that?
here.
Hello?
I know. Alright, I'll call you, what, you think a couple hours?
could be
Maybe a couple
slightly
hours.
more than that.
More
It's
than
not,
that.
That's up to, I don't know what that process is.
And they have you in front of the store? Like, they won't put you in the office or anything?
They're waiting for the lady to come. I asked him to take me out the side door, but I don't know. He said he's not gonna put me in handcuffs. Yeah. But Jenna Tori, you're friends with Jenna on Facebook, right? So you can call her. Jennifer.
How long is she gonna be there for?
She works till 2:30. Please don't tell Alan or nobody else yet.
Well,
I'll tell myself.
Jesus, if you needed help with
Yeah.
something, you should have told me.
Alright.
I would have helped you.
Yeah.
You could have came and lived with me. I already told you that stuff.
I know. Alright.
I don't care. Get mad all you want. Like, this isn't a game. It's gonna be on your freaking record. You know how hard it is to
I know. And Miguel told me that he wasn't gonna get arrested. Alright, I'm gonna let you go because he's letting me use the phone I'm not supposed to. Alright, don't tell nobody, please.
I won't.
Love you. Bye.
Hey, it's Ivan. They have somebody coming?
Thank you.
If you do, just send her to the office. We'll do the search here and then. Yeah. Alright. Thanks. Yeah, we'll just wait for it to get here.
Stanford back.
Do is
Chevy.
walk out, go to
So
the
the
other side of my
Daniel
car.
out
I'll
of-
handcuff you there real quick. And
It's over there.
Caravel?
car is right out here,
Okay.
but I'm parked like facing that way, so I'll be
Okay.
facing away from this stall.
Did my boss tell them that he said I wouldn't get arrested?
Thank you. I know. There's a deputy coming in. If you go. Shoot. They might not be familiar with the store like we are. I'm sorry.
She says it's 13.
Yeah. They,
Standard prior call, zone 12, still $42, General 1113, West First Street, 1113, West First Street. I just follow it up.
Do you want to go to the bathroom?
hello.
Hey.
Hi, come on in. It's right here.
Hank, we're waiting for finish briefing.
Do you want to go outside and do it, or you want to do it in here?
Yeah, let's do it in here.
Okay. One minute.
Leave the door open. I don't have to get arrested, right?
No.
Okay.
Just put your stand up. Face the wall.
Stanford back to 32, blackmail subject,
I'm
one
gonna pull
last
your
thing
bra
wearing all
out.
red
This one,
clothing on foot,
this
and
one.
one last thing wearing all black clothing.
This is the
What?
thing of my bra.
Pull your backpack, turn
Why?
to the bicycle. So,
2-4-51 of the priorities from this morning.
The supervisor's conduct deserves scrutiny. Only a state attorney or authorized prosecutor has the legal authority to offer immunity or non-prosecution agreements. A store supervisor, regardless of rank within the company, cannot bind law enforcement or the prosecution to any such promise. Making this promise, whether through deception or ignorance, constitutes obtaining a confession under false pretenses. When the officer requested the supervisor's identification to document the coercion allegation, the supervisor refused, claiming he had committed no crime. Under Florida law, individuals are not required to identify themselves to police unless lawfully detained based on reasonable suspicion. The supervisor was technically within his rights, but his refusal complicated documentation of his own misconduct. Regarding the suspect's motive, financial hardship and personal tragedy, while deeply sympathetic, do not constitute a legal defense to theft. Florida's theft statute requires only that the defendant knowingly obtained another's property with intent to deprive. There is no hardship exception. However, mitigating circumstances significantly influenced sentencing, as this case ultimately demonstrated. The suspect was charged with felony grand theft under Florida Statute Section 812-014 and received 5 years of felony probation. This sentence is consistent with a first-time offender who cooperated with law enforcement, expressed genuine remorse, and whose offense was driven by personal crisis rather than greed.
Let's examine the constitutional framework.
The lead officer receives an A-. The officer demonstrated exceptional legal knowledge and procedural discipline. Upon discovering the coerced confession, the officer immediately identified the problem, refused to use the tainted statement, and re-Mirandized the suspect before any further questioning. Beyond the legal handling, the officer showed remarkable empathy, allowing a phone call to the suspect's daughter, arranging a discreet side door exit, and declining to use handcuffs given the suspect's full cooperation and the non-violent nature of the offense. The suspect receives a C+. Stealing thousands from an employer is a serious felony regardless of motivation. However, her cooperation with law enforcement, lack of resistance during arrest, and the devastating personal circumstances that drove the offense, losing both her mother and brother, prevent a lower grade. Her critical error was providing a written confession to her employer without legal counsel, based solely on a verbal promise from someone with no authority to make it. The Dollar General supervisor receives a D. While claiming good intentions, the supervisor made a promise of non-prosecution that was completely beyond his authority, effectively coercing a confession under false pretenses. This did not help the investigation. It actively undermined it by tainting what could have been valuable evidence. The supervisor then refused to provide identification when officers attempted to document his conduct. Good intentions do not excuse legal ignorance that compromises a criminal investigation. 3 lessons from this case. First, never provide a statement, written or verbal, to anyone based on a promise of leniency unless that promise comes from a prosecutor through your attorney. Employers, supervisors, and even police officers cannot guarantee immunity from prosecution. Second, if you are accused of a crime, invoke your right to counsel immediately. Everything else can wait until your attorney is present. Third, for employers and loss prevention professionals, do not promise employees that cooperation will prevent prosecution. You do not have that authority, and making such promises can result in confessions being thrown out entirely, weakening the very case you are trying to build. If you suspect employee theft, document the evidence, contact law enforcement, and let the legal process work as designed. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.